ADR Skills Program. My name is Peter Phillips, and I'm the director of the Alternative Dispute Resolution Skills Program at New York Law School. We are very excited that for the second event of this season, we have a trio of highly expert speakers on a topic that is becoming increasingly critical to global commerce, and that is the resolution of disputes involving investors on the one hand and sovereign states on the other. Moderating for us today is Barry Appleton, who, in addition to being an eminent expert from Toronto in the area of investor state, is astonishingly for us a professor here at New York Law School, and I brag on him on a pretty regular basis. We're very, very excited that he is with us, and our students are very excited to get the benefit of his expertise and his amazing career. So I'm going to stop talking. Barry, thank you very, very much for doing this, and off you go.
Well, Professor Phillips, I want to thank you and everyone in the program for inviting us. We have a very exciting program today with some spectacular people on our panel. So I'm kind of humbled by being able to have them to be able to join us today, talk about this very important topic. And so, as Professor Phillips had noted, I have spent my entire career dealing with the issues of investor-state arbitration. Those are the disputes that involve governments on one side and investors on the other, thus the name investor-state. But today, we're not talking about the nature of the disputes. We're going to talk about the ways to be able to use ADR skills and mediation to be able to come up with a better solution, perhaps to be able to avoid the issues that go along. And so there are 3,340 treaties. I'm the editor for Westlaw of the investor-state treaty set. So that's the current number that they have registered. And so how do you deal with resolution of disputes in this way through mediation? By the way, for those of you that don't know very much about investor-state treaties, a good example would be the NAFTA agreement or the Trans-Pacific Partnership. But there are many, many agreements for many states to be able to get over 3,000 of them. And not surprisingly, there are a large number of disputes. Now, investor-state disputes are unique in the area of arbitration because they raise public policy questions, could be public law, and yet use the mechanism of international commercial arbitration to get them resolved. And so we have issues about legitimacy and public policy that come in to the arbitration context, and that can be particularly challenging. And our panelists today are going to talk to us about how we deal with those challenges. Now, just before I introduce them, because this is a CLE program brought to you by the New York Law School ADR Skills Program, I need to just tell you what the rules are. I'm going to interrupt our speakers occasionally because I have to give you 3 code words. And if you want your CLE credit, you have to respond back to us with the 3 code words so we can provide that to you. So I will do this at 3 points during the program to ensure that you get the right information and get your CLE credit. And even though it is a little early in the program, I'm going to already cheat and give you the first code word, even though it is earlier, because I do not want to interrupt. And so the first code word is NYLS. NYLS is the first code word. I will come back to you with 2 more code words as we go along. Now that we got the business part out of the way, and of course, the second part of the business is that we are going to have questions and answers. So we are going to be monitoring the chat. Please feel free to use the chat screen. And we're going to have questions and comments as we go along. But we have 2 spectacularly qualified and interesting speakers today. And so I want to turn to them rather than turn to me. So let's start by introducing Wolf von Kumberg. Now, Wolf is the world's expert in the area that we're going to deal with here about mediation. Wolf works with Arbitra. He is speaking to us tonight from Italy, but he spends a tremendous amount of his time in Dubai. Is that correct? Or in Abu Dhabi?
Abu Dhabi.
Abu Dhabi, thank you. And he is, well, let's go back. First of all, Wolf spent over 30 years dealing with commercial disputes. He was Assistant General Counsel at Northrop Grumman, but then he took all of that tremendous expertise and understanding and information and focused on how to use it to mediate disputes, the way of the peacemaker, to see if we could resolve matters. So Wolf has been working extensively on investor state ADR. Is going to tell you about the developments in the field, the impacts that are there, the best practices and the new practices, and the new treaty that came into force during COVID that is going to be relevant to deal with us today. He is going to be followed by one of our esteemed New York Law School graduates, Isabel Manfredonia, who is an associate at Squire, Patton, Boggs in New York. And Isabel works on investor state cases, particularly with one of the key bodies, the World Bank's ICSID, ICSID. You'll hear a lot about that today, so we just wanted to get that out of the way, what the ICSID was. And she's been working on cases. Now, ICSID cases tend to take at least 4.5 years from the beginning to the end. And she's told me she's already had the opportunity to do hearings in 2 over the last 2 years. So I'm really excited that she's had that experience. And I'm hoping that she can also talk a little bit during the program about opportunities for new students of what they can do in this very exciting field. Because I've had the opportunity to be in this field for a long time, but I know there are tremendous opportunities for young grads in this as well. So we're going to turn everything over to Wolf. I know that you have some slides, and we'll go from there. And then I'll make sure that we get questions along the way, including some of the questions that are coming in from the chat already, and we'll get through all of those now. So without any further ado, I'm going to turn it to Wolf, and let's see if we can talk about this amazing new set of issues about the ISDS mediation rules and approaches. So Wolf, take it from here.
Thank you very much, Barry and Isabel. Great to share the platform with you. And Professor Phillips, thank you very much for inviting me to this. Peter Phillips and I have gone a long way back dealing with ADR, and it's a real pleasure to be here today. But as Barry said, what we're trying to cover here in a very short period of time, actually, are developments that have been occurring in ISDS. So Barry has already alluded to ISDS being something that is critical really to the world trade and the development of world trade that we've seen, because it deals with the dispute mechanism in investments. And traditionally, that has largely been arbitration that has been utilized. As Barry said, it's akin to what we know of as commercial arbitration, dealing with matters which often are within the parameters of a state and the sovereignty of a state. So it's an interesting development, and it's really something that developed out of the creation of the World Bank and of ICSID, which is the part of the World Bank that deals with disputes. And ICSID has had arbitration rules. It's also had something called conciliation rules. The conciliation rules, so, should not be confused with mediation, because they are a very different format from what we know today as mediation. And the conciliation rules in ICSID have not been utilized very often. I think there have only been about 13 cases, Barry, in the last 50 years, whereas arbitration is typically utilized. And Isabel was just telling us that she's been involved in a number of those cases. So it's something that happens quite frequently. But what I'd like to talk to you a little bit about is the development of mediation within the ISDS framework. And that's really been very recent. It's only been the last 5 or 6 years that there has been a considered effort by a number of institutions to try to bring mediation into the investment dispute arena. Perhaps what I could do is I'm going to share a few slides with you. I don't want to overkill you with slides, but let me just get that up there for you. And I wanted to run through some of those developments that have occurred. And this slide's a bit busy, but there's quite a bit that has been happening. So ICSID, as I said, that part of the World Bank that deals with investment disputes, has been really one of the drivers towards the use of mediation. And in fact, in this year, in March of this year, ICSID actually promulgated its own mediation rules. So in addition to the arbitration rules and the conciliation rules, ICSID now has mediation rules. So given that it's the primary body that deals with these investment disputes, mediation rules gives now mediation a lot of credibility within the ISDS framework. But in addition to ICSID, the other organization that has really been a driver towards mediation being incorporated is the Energy Treaty Organization. So the ECT is the Energy Charter Treaty Conference, and that is a membership of about 55 states that deals with the production and transit of energy. And that organization, which is based in Brussels, has a treaty which deals with energy disputes. And in that treaty, there is a reference to conciliation. But nothing more than a reference to it. And there's nothing that tells you what conciliation is meant to be or how it's to be utilized. And about 5 years ago, in talking with the General Counsel for the ECT, we thought that it might be worth exploring whether mediation might not be utilized within the ECT and really taking the conciliation provision and putting some meat around it. As a result of that, the ECT, first of all, put out a mediation guideline. So the guideline, which can be found on the ECT website, actually goes into quite a bit of detail as to what mediation is, how mediation can be utilized, and in particular, how it might be utilized in energy disputes. And so that was really the first step that the ECT took to help educate its member states as to what mediation was and how it might be used. The ECT, however, quickly realized in discussions with its member states that simply having a mediation guideline wasn't sufficient. And Barry's already alluded to this fact. And that is that states, rather other than commercial entities, and I can associate with that because I spent many years with global companies, we could use mediation. When we thought we wanted to write it into our disputes clauses, we wrote it into our disputes clauses. But it's much harder for a state to actually utilize mediation. It's much harder for a state to negotiate settlement agreements. And why is that? Because states, of course, have a lot of other considerations rather than simply commercial considerations to worry about. And many of those are political, they're social, they're economic, and in particular, state officials often feel that they don't have the authority to enter into a settlement agreement or to enter into a mediated settlement. And so that's a real issue for mediation. How does the state official at the mediation even have the authority to enter into an agreement? And so the ECT, understanding that that was an issue from its member states, has created another document, which is very interesting, and I would really highly recommend you take a look at it. And it's called the ECT Model Instrument. Again, you can find it on the ECT website. And the model instrument is a framework that's being created for states to incorporate into their own state organization. And it deals not only with mediation, but with disputes generally. So it could be an arbitral dispute as well. But it creates a framework for the state to deal with a dispute when it comes in. And many states don't actually have an organized way of dealing with disputes. And this framework provides that kind of organizational structure. And it allows the state to then nominate who it is that is responsible for a dispute when it comes in, and who has authority to deal with the dispute, and who has authority ultimately to agree a settlement, whether it be a mediated settlement or a negotiated settlement. And so that's a framework that's already in place and really creates the background for a state to even be able to mediate. And that's extremely important. There are a couple of other developments, I think, that are important to this area. One, as Barry has already said, is the Singapore Convention. The Singapore Convention, or the Singapore Mediation Convention, is a treaty that has already been signed by 55 states, has been ratified by 9 states so far. It just came into being in 2019, so that's quite a remarkable achievement. And it's a bit akin, if you're familiar with the New York Convention with respect to the enforcement of arbitral awards. It deals really much in the same way with the enforcement of cross-border mediated settlements. So it has to be cross-border. It can't be a domestic mediated settlement. But if it's cross-border and there is then a ratification mechanism whereby the mediated settlement can be enforced in other states. So it's something that, again, is a kickstart the way the New York Convention was for arbitration or international arbitration. This is going to be, I think, a kickstart for international mediation. And the reason that's important in the context of investor state, more than simply enforcement, I think, again, it gives legitimacy to mediation, because clearly the states that are entering into that treaty feel that mediation is a mechanism that may be employed. And so it gives it credibility, and that also enhances its use in investment disputes. And then there have been a few different guidelines that have been that have come out as well with respect to investment disputes and use of mediation. Just very recently this year, CEDAR, which is a UK-based mediation institution, worked with about 16 law firms that are involved in ISDS to create a guideline, which is a very useful guideline. Again, I would suggest you take a look at it on the CEDAR website, and it'll give you a good overview of how mediation might be used in these disputes, and also talks about some of the obstacles to using mediation and how those obstacles might be overcome. And then finally, there have been a number of efforts by ICSID, ECT, and CEDAR together to train both investor state mediators, because clearly you need mediators if you have mediation in this forum. Commercial mediation is quite a bit different from IS mediation. And so you need to have mediators that also not only understand the skills of a mediator, but also understand it in the context of ISDS. And so that's what this training has done. And they've also been training state officials so that they are familiar with mediation and might be able to employ mediation. And so there is now a panel in Abu Dhabi, as we talked about at the ADGM in Abu Dhabi for investor state mediators. So it's a place where people can go and look for an investor state trained mediator. And I'm sure there'll be more panels coming out in the future. Just very quickly, and Barry, let me know when I'm running out of time here, but I think it is worth looking at the types of cases that are suitable for mediation in this context, because every case will not be, and it will also depend on where that case is in the process as to whether mediation should be employed. Yeah.
Just before we go there, before we leave off on Singapore, many of the members of our audience will be very familiar with the New York Convention, and they'll know about how important and successful the New York Convention has been in terms of its role with arbitration. It's really the sine qua non. If you're dealing with arbitration, you have to always think about enforcement in the New York Convention. So the Singapore Convention came into force in 2020 after it got enough ratifications. And so do you think Singapore can sort of live up to its billing as sort of the New York Convention for mediation? Like, do you think that's a possibility here?
Well, I know others might differ, and I defer to Professor Phillips here, who is or has been in the past perhaps not a great fan of the convention. But I think, well, first of all, to me, the most important element is the fact that it gives credibility to mediation in an international context. But I think it is also useful because often when you talk to people about mediation, they say, okay, that's great, but you got a settlement agreement, but is that actually enforceable? How do you enforce that? I mean, you hear that in a domestic context too, right? And then you say, well, it's actually a contract, and so you can enforce it in court as a contract, right? But for many people, that isn't good enough. They want to be able to take it to a court and say, would you please enforce this for me now? And that's really what it's meant to do.
The reason I asked that, Wolf, is that I'm the chair of the American Bar Association's International Arbitration Committee. And we've had some questions on this very topic at our last meeting just a few maybe it was a week ago today, actually, it was a week ago today, where people would say, well, is there a point at actually having a mediation in an investor state case if you couldn't settle it? And so many people thought that they couldn't actually effectively have mediation as an option until after Singapore came into effect. And so that's really what I was trying to get at is, do you think it's important? I guess your answer is yes. Certainly, yeah. I've been doing this for almost 30 years. And in the past, people would say they wouldn't have mediation because they wouldn't get an effective result unless we confirmed it as an order of a tribunal. So you think it's better?
Well, I mean, it's an interesting point, Barry, because, one of the issues, and Isabel can probably speak to this as well, in arbitration and arbitrating investment disputes is you do get an award, but then you have to go enforce that award as well. And you think, well, I mean, it's quite easy to enforce an award against the state, isn't it? Well, I think there have been situations where it hasn't been quite that easy to enforce against the state, and we can probably name a few of those situations. So, so a mediated settlement, and usually a mediated settlement, I would say in my own experience, parties that agree themselves to a settlement tend to then abide by it, simply because they've already put the terms into it that they feel they can actually comply with. So it's different than having an award that is enforced on you, and you try to find a way to get around that. So I'd say generally mediated settlements are going to be more apt to be complied with anyway than arbitral awards, perhaps. But you do have that added assurance, and you're right, Barry, that well, because of the Singapore Convention, perhaps you're going to be able to enforce it as well.
Well, just before we turn to the areas about the types of situations that might lend themselves to mediation, I thought maybe we might turn to Isabel and give her the question you asked, whether she had something she wanted to say about the idea of settlement in investor state before we got to those types of situations. Isabel, do you want to weigh in here, or you would like to wait till later to jump in?
I'll jump in more later, but I'll just quickly say that I hear what you're saying, and I agree. I typically represent the state side in investor state disputes. So from that perspective, I think it goes both ways. Like what you were saying, they may want to have more of a say, settle something early, and have more control. But on the other hand, I could see some of our clients saying, no, we want it to be more structured. We want the decision-making power to go to the arbitrators. Maybe they feel that's less risky, more risky. I think it just depends on the case. It just depends on the amount in dispute and the party's interest.
Well, you're certainly right, Isabel, that the factors that we look at with investor state are different from commercial disputes. And I'm sure Wolf is going to take us through those types of issues now, because there are different types of issues. It's not just a question of economic rationality. You have a lot of rationalities or irrationalities you need to consider in the whole picture, just like you have to do with other types of disputes. So, Wolf, why don't you take us through that?
Yeah, well, I mean, let's take a look at where mediation might be effective in investment disputes. And as Barry says, and it's quite right, I mean, the state has a lot of other considerations, not just the commercial consideration. The company, in a sense, is in a good place because they just have to look at the cost benefit of a particular settlement. Am I going to do well for my shareholders by agreeing a particular settlement, or am I going to do better if I proceed through to arbitration? But the state has a lot of other factors. Political factors clearly are an important element to that. There are social factors. I mean, communities are often involved in these investments, and also the repercussions from these investments when they perhaps go bad. There are things like environmental issues that might arise from an investment, and so the community could be affected. There are economic factors involved as well. I mean, their taxation often is an issue, and the changing of tax laws that might affect an investment. There are health and safety issues, and we just look at the tobacco industry and some of the cases that came out of tobacco when countries started to restrict the sale of tobacco and cigarettes, and that obviously impacted the companies that were manufacturing those, but states felt that they had a legitimate reason for it. And now I think right now it's really apt, because I just saw an article about it today, and the impact on the ECT, the treaty I was just talking about earlier. Mm-hmm. Environmental transformation and environmental changes that are taking place, and where states have, again, treaty obligations to meet the net zero goals. They're going to drastically start changing the way fossil fuels are mined or drilled for and extracted. Those long-term concessions that they've often given oil companies, it might be 30 years. All of a sudden they're saying, no, we want to get rid of those in the next 10 years, right? So what's the impact on the investment made by the oil companies? Well, that's going to lead to potentially a lot of different disputes. So these are all factors that states have to take into consideration that commercial companies don't necessarily have to take into consideration. So but where do we see some areas to perhaps utilize mediation? Well, I mean, to begin with, investments are made by an investor in a state because they think that they will do well commercially through those investments. And the state wants that foreign direct investment, the FDI as they call it, because that obviously helps the economy of the state, provides jobs, brings investment and growth into the country. And so there's a relationship, just like in any commercial relationship, there's a relationship between the state and the investor. And when issues arise and there may be changes that are made, as we said, to the local laws, there is an opportunity through mediation, through a facilitated negotiation, which is really what mediation is, to perhaps relook at the legal relationship and restructure that legal relationship. And you still want to maintain that relationship, but you want a mechanism to allow you to perhaps make changes to the original agreement. And so that's where mediation can play a role. And so that's a very important role. I mean, while there's still a relationship between the investor and the state, there is a good opportunity to utilize mediation in that context. The other area where I think mediation plays a role is really when you come down to what it is that is in dispute. The arbitration process, and Barry and Isabel can attest to this, generally will result in a monetary award. There will be a decision based on the economic loss of the investor, if the investor in fact has a legitimate claim, and there will be monetary compensation that's paid. I mean, that's generally what will come out of an investment arbitration. But in fact, there may be a lot more that can be done than simply look at the monetary damage. And again, this is going back to some of the other aspects of an investment, and that is there can be changes to laws that are made. There might be further investments that could be an incentive for changes to be made between the investor and the state. There might be local remedies, like the investor agreeing to build schools or roads, or perhaps there's an environmental cleanup that the investor has to agree to partially fund or fully fund. And so there are other ways to deal with issues as they arise other than simply a monetary compensation to be paid. And so again, that's where mediation can play an important role, particularly because in mediation, you can bring a lot of different stakeholders around the table, not just the two principal parties, the investor and the state, but for example, the community, if there's a community issue, because the mediation process is a very flexible process and not restricted to the actual parties involved. If everybody agrees that the community can also sit around the table, then the community can sit around the table, and you're going to get a more robust resolution out of that. The earlier you have a resolution, and the earlier that mediation is built into perhaps the way states deal with investment grievances by the investor, probably again, the better the result will be. And that's another incentive for mediation to be utilized at an early stage before positions become too hardened, but perhaps more important, before immense amounts of money are spent on this. I think the ICSID statistics on the cost of an investment arbitration, and this is just the average one, is around $15 million. And so that's a lot of money for the investor and the state to be paying. And once you get hardened positions and you get through to a place where there is arbitration that has been commenced, it's harder to resolve that through mediation. An important element of mediation is also that the parties maintain control over what they do. So, as I said earlier, if you can enter into a settlement agreement, parties have agreed to that themselves. They're not being forced to do something by a tribunal. Of course, once it gets to arbitration, there's going to be a winner and there's going to be a loser. So everybody's not going to walk away from that very happy. And whereas a settlement, you might not be ecstatic about it, but you feel that it's the best result you can get and you agree to it. And it's something that you yourself have agreed to rather than have had imposed. And then I've already referred to the ECT framework, the model instrument. If there is something in place within a state to allow it to negotiate, allow it to mediate, that will make it much more plausible that a mediation can take place rather than if it were ad hoc. Very difficult to get state officials actually to agree to something like that. Well, maybe I'll just pause there for a moment. Barry, Isabel, anything there that you would like to discuss?
No, just to jump in, I just see something. I was just looking at the chat here.
Yeah.
We'll get to the questions at the end, but just this one seems more relevant. The question is, what organization is training mediators, or I guess now mediators, if you're pursuing via the ICSID rules, are they all coming from ICSID, or how does that work? Do you have any insight on that?
Yeah, so as I said, ICSID, the ECT, and CEDAR, the three organizations together have run training programs for IS mediators for about 3-4 years now. And they're held in different places around the world. And I think they've held about 6 or 7 training sessions since they started. So there's at least 1 or 2 a year that are being held. These are, though, for people that have already got a mediation background. So they're not teaching you the mediation skills. Rather, they're teaching you the ISDS framework for the utilization of mediation. So you'd first have to get your mediation training before you could take one of those courses.
And Wolf, there is no certification at this point for
No,
specialized ISDS mediation.
Yeah, so IMI, the International Mediation Institute, which you might know about, which is a non-for-profit organization that tries to create standards for mediators globally. And they have a standard for just a general mediation training program. And if you take that, then you'd be certified by IMI. They have also worked on investor state mediator criteria. They haven't actually completed that yet.
Right.
But there may then be an international standard through IMI.
Yeah, no, I'm expecting this to develop. Of course, it's interesting because I expect we have tremendous numbers of trained mediators in the United States who would be very interested in these very complex and interesting problems. But we want to figure out if there's a way to certify, not just on the investor state side, but actually also about the process of mediation. There's many different layers, and we'll talk about that in a moment, but it's time for a code. So again, I just want, so some of you came in just after we did the first code, so I'm going to repeat that. So I'm going to give you 2 of the 3 code words right now. So the first code word was NYLS. That's just to remind you, because I did it a little early. The second code word is ADR. I'll repeat that, ADR. And you'll need to stay tuned to get our third and final code word later in the program. So, Wolf, do you want to take us through some more here, or shall we turn over to Isabel? It's entirely up to you. We have more time if you've got
why
it.
don't we turn over to Isabel? I do have a final slide that still looks at what can be done to enhance mediation in this field, but why don't we let Isabel carry on? If we
Isabel,
have
would you
time,
like
I can
Wolf
get-
to do his final slide first and then comment, or would you like to start now?
I'll comment now because a lot of it's just gonna be sort of echoing what he said on this slide, and I'm just, on the types of cases and that sort of thing. So, and then we can go to the last slide. So I guess first, in terms of what you said, time and costs, that's the main consideration that I think states and investors take into account when they're deciding to enter into an arbitration via one of the institutions. And of course, arbitrations, as Barry mentioned, can take anywhere from 4 years. Larger disputes can take even longer than that. So it does take a very long time. And of course, millions and millions of dollars go into that on both sides of the dispute. But then now with mediation, now that there is finally institutional mediation rules, maybe we can see faster settlement opportunities and less money. Usually states and investors both strive to settle something early on, regardless whether it's via mediation or even a more informal, just between themselves without a neutral third party. So I do think that, once they sort of see some more states try it out via the institutional rules, it will become more popular. But it also just speaks to what you had said about the state settlement framework, I guess. Not as many states may be as prepared for this sort of thing in terms of controls, who would be handling it, who would be participating in the mediation, things like that. So I think that and this is not an every case, I'm just thinking some, definitely this is common though. So they would need to be prepared in that aspect as well. And also the enforcement mechanisms, that would be maybe something that discourages it as well, or encourages it if depending how it plays out. So it's sort of a wait and see game, but whether it's enforcing a regular cost award or an adverse cost award, it always runs into issues, even via arbitration. So I imagine with mediation, it'll come into the same barriers. But other than that, the rules and a lot of the control factors, neutral third parties and the structure of the rules with confidentiality and things like that are honestly very similar. So if it can save time and money, and be perhaps even more productive, I could see it becoming more popular. And also a lot of the BITs, the investment treaties, have either always had or over the last 10, 20 years are continuing to add provisions that expressly provide for mediation, as opposed to something broader that might just say amicable settlement of disputes before proceeding to arbitration or something along those lines. So I think that if there's also more of a structured process in the BITs as well, that will encourage it. But that's just my 2 cents. I mean, I haven't come across anyone that's enthusiastically said mediation yet, but I just think it's because a lot of it is so new and so fresh, and they're not sure of the benefits and, more importantly, the cons. There's a lot of benefits, but they may not know yet what the cons of it could be.
Now, Isabel, maybe I could ask you, because you do work representing states, and
Right.
states are very important factors here in terms of mediation. If you lose an investor state case, you can blame the tribunal. But if you settle or mediate, somehow you're involved in that. That's the whole reason. But then you can be blamed as well. And would that be a factor you think that might make it more difficult? Or would you think it'd make it better because you can shape the result? I mean, what's your sense of that?
It's difficult. I mean, states are always concerned with the public image and how any news that comes out about a case will be reflected poorly or more advantageously on the government to its population or to future investors. So I think that there is a concern of placing blame and liability in one place or another. But I don't know. I still, I wish I could have a more concrete answer, but I still think that they could see that as a benefit, as in, we presented our interests here and we're able to get a more, positive outcome versus via arbitration where we fought for our rights and they denied us those rights. So I don't know, but definitely the public image and reputation of the state in terms of investment environment and the population therein is a high concern.
Well, let's ask the same question to Wolf. I most recently saw Wolf on a panel in Madrid on this very topic, and I know he's just come from another panel, at least that was at ICA in Edinburgh, maybe even another one after that. So I mean, he gets around on this. He hears lots of different positions, both from investors and from governments. Wolf, what do you think about what Isabel has to say? Do you think that's the whole story? You think there's more? I mean, what do you think?
No, I think there's a legitimate concern on behalf of state officials. And if you'll recall, in Madrid, we had somebody from the Czech Republic on our panel. There is a real concern for state officials who then feel that they might be exposed to any kind of settlement, and if their name is beside it, particularly because once there is a situation in the state where it becomes clear that the investor or the investment is being criticized, perhaps there are environmental issues, for example, and in a mining situation, there's a lot of bad press in the papers about the investor. And all of a sudden you then do a deal with the investor. Why did you do that? I mean, you've been saying for the last year that this has caused a lot of damage to our state, and yet now you're doing a deal with the investor. So that becomes very difficult because it's politically fraught with a lot of issues. At the same time, there are situations where clearly it's going to be to the benefit of the state that they do reach some type of agreement, whether it's to allow the investment to continue or if it's to actually have the investor depart in some fashion. It's going to be better to do it through an agreement rather than having to see whether a tribunal will find in the state's favor, because the tribunal might very well not find in the state's favor, and it'll be extremely costly for the state after going through that whole process then to have exited the investor. But of course, as you've pointed out, you could then say, well, that was the tribunal. But when you actually look at the economics of it for the state, that's not really in the best interest of the state to do that. So it is difficult. And that's why, as I said at the beginning, the ECT has this model that would allow at least there to be a framework through which the state official could then operate to be able to agree a settlement and point to that as being the mechanism. So there's a legitimate mechanism then in place for them to utilize mediation. So that's an important aspect, I think, to it.
Isabel, do you want to comment on anything else before we let Wolf go back to the last part of the slide? And I do want to let our audience in.
Yes, definitely. No, that's okay for now. Carry on. I'll say some stuff towards the end.
Okay, well, let's turn back to you, Wolf, because it's really interesting. I mean, these are very complex issues. I see they're high value, complex, and often public. They're difficult, maybe sometimes even intractable. So tell us where we go from here.
Yeah, well, I mean, there's another good example that I can cite, which is in the public domain. I just read another article today where it's cited, and this is a great example of how states can actually get it wrong, and it's very costly for the state. So Italy, the state of Italy, it canceled a gas concession that a British company, Rockhopper, had. And it arose really out of, and this is often the case in these situations, there was an election in Italy in 2015. There was a party that came into power, which was very much oriented towards the environmental side, or they had a lot of supporters from the environmental side. And so they just decided that they weren't going to have any more gas concessions, and they terminated this concession with a company that had other investments actually in Italy as well. It then became an exit case. The determination of the tribunal just came out a couple of months ago. The award against the Italian state was 250 million euros and interest at 4% from 2015. So it's all of a sudden, it's a huge amount that Italy has to pay for something that they get no benefit from now at all. In fact, they're buying gas from Croatia, which is the neighboring country where this gas field was. So the same gas is being utilized anyway. So even from an environmental perspective, it didn't really serve any purpose. So you say to yourself, well, why didn't they just sit down with the investor at some point? Because this investor had other investments in the country as well, and just hammer out a deal. It probably would have been much to their advantage to have done that. But, and I don't know what the reasoning was behind the Italian state's decision, but obviously there was a reason why they didn't do that. And it was probably because nobody, had either the mandate or felt they had the authority to do that. And so I think that's a great example of where perhaps mediation would have made much more sense than to go through an arbitral hearing and an award. So I think, as countries and particularly states in this case, because I think investors are more apt to mediate because it's just a commercial decision that has to be made, and internally within companies, if they feel that it might be worth their while to mediate, then you're going to have the authority to mediate, whereas states, as we've already discussed, have more difficulty in doing that. And so, but as states, I think, become more aware of, and as counsel for states become more aware of the potential for mediation to be used, I think there will be more use of it. Maybe just going back to my slides quickly. I think it's probably worth just taking a look at at what point in time mediation might be useful in these types of disputes. So we've already talked a little bit about pre-arbitration. So if the state makes it part of its grievance procedure, so whenever an investor feels that they're not being heard or being dealt with in a manner which they feel is effective by state officials, that they could bring a matter to mediation with the state, and there would be an attempt to try to resolve the issue at an early stage in a conflict, which is always the best time to try to resolve something. The other point in time is where there might be a determination by an investor to commence arbitration proceedings and to give notice of arbitration. But before doing so, they might give the state an opportunity to mediate with them, with the alternative being that arbitration might be commenced. So it's before the arbitration is actually commenced. Most bilateral investment treaties also have a cooling off period within them. So after notice of arbitration has been provided to the state by the investor, there's a period of 3 to 6 months where there's an opportunity for the parties to actually try to resolve the matter. Typically, that never happens during that period. Maybe there are some negotiations. Barry, you maybe have utilized that period to negotiate, but typically the parties are getting ready for the arbitration. The state is trying to figure out what this is all about because they don't have a very good handle on it. So nothing is really done, but that is a good period. Barry, what do you think? A cooling off period?
Well, it's interesting, in most cases, the state says we don't have enough information because the cooling off period is before the claim is brought. It's
Right.
after a notification of a dispute, which can be quite general. And even when you have a situation, if you have a very detailed notice, it's just the same as the notice of arbitration. The states usually say, well, we're not required to do anything, so we're not going to do anything till we see your pleading. By that time, you're in very considerable cost in the process. The parties are starting to dig in, and then the other side still hasn't said a word, the state, and therefore that would normally be a good spot, actually, not the cooling off, but after you file your first pleading. But then that's when people can start to get angry, because obviously they put out a pleading. It says, oh, the other side's done all this terrible thing, and they maybe they're going to say, oh, we can't mediate yet because we haven't had a chance to say what our position is. And so you get yourself caught into positions, and mediators have to often work through that. And so that's the problem here. The system itself doesn't lend itself nicely to easy points in time to where mediation would take place. Whereas in a commercial context, it might be easier than in the situation where you're dealing with states and investors. But I open this up, and maybe the audience will have something to add too. So we'll throw it to them as well when we get there. Because I know you've got
Okay,
more to say
great.
here, Wolf. So, but it's tricky, isn't it?
We'll just finish it off here. So, I mean, the other possibility is to run the mediation in parallel with the arbitration. That's increasingly being done in commercial cases where also institutional rules require mediation to take place either before or together with arbitration. And there's no reason why it couldn't also happen in investment cases where perhaps the parties, as Barry just said, have triggered the arbitration proceedings, but they still want to leave room for negotiations to take place, and so they also appoint a mediator, and so the mediator can deal perhaps with some portions of the claim, and other portions go to the tribunal, or perhaps the damages come back to the mediation, so that the parties, after there is a determination by the tribunal, might still deal with the damages, which in investment cases are very complex, usually require a lot of expert evidence, but the parties themselves might come to a much more comprehensive agreement on damages, and perhaps that's a possibility as well. And then a post-award. So again, their award might already have been rendered, but then dealing with the payment mechanism and how payment's going to be made and over what period of time, and maybe there is still opportunity to discuss, some further investment as part of the resolution. And so post-award is also an opportunity for mediation to take place. So that's really the timing side of it, Barry. And I think with that, maybe we can open it up.
Well, just before we go there, I want to ask you, we've heard how expensive litigation of these claims could be. And we know how long it's going to take. What's your sense with respect to the time for mediation and roughly the cost? So we have an idea of comparison.
Right. So, and ICSID has actually looked at this and sort of with respect to their rules and sort of what the timeline would be. And so their estimate is around 6 months. And 6 months because there is a fair amount of process design work that has to be done up front by the parties. What is the process going to look like, particularly because it's state involved, and getting authority for whoever is going to attend from the state, who's going to attend from the state, where is it going to take place, maybe there are language issues, interpreters needed, press protocols, that's going to be important for a state generally, so there's some agreement on press protocols, confidentiality, as Isabel has already mentioned, when a state is involved, those would also for arbitration. There's some transparency that is required. And so there's got to be an agreement between the parties as to how much transparency there actually is. So there are a lot of administrative matters that have to be dealt with before the actual mediation commences. So 6 months is probably not an unreasonable amount of time for a mediation of this sort. As far as cost is concerned, it's difficult because again, it's going to depend on the complexity and the length of time and the number of mediators. So the ICSID mediation rules, interestingly, allow for co-mediation. So you can have one mediator, or you can have two mediators that work with each other and co-mediate the matter. So that might very well be what you end up with. That'll be more costly, of course, as well. Maybe there's an institution involved, and so there's some institutional costs. But it's nowhere near the average of 15 million. It's probably closer to, I would say, probably $1 million, perhaps, maybe not quite as much, but of course, it depends on counsel and how many lawyers the state and the commercial party has as well. So there are those costs in addition. So, but it will. I mean, it's the time consideration, and when you think of it takes 4 to 6 years for an ICSID arbitration, if you can do something in 6 months, that's going to be a big savings.
Okay, well, that's fabulous. So before we turn over some questions, and I see that there are questions in the chat, and Isabel's going to take us through that, I have to just do my last official function, which is to give the last word for those who are doing CLE. Okay, and the last word, for those of you who are following along, our last code word is mediation. So I'll just repeat that. The code word is mediation. And with that, I'm going to turn over to Isabel. It's all up to you now. So take us through questions, take us through things, and let's see where we go.
Great. So I see some questions in the chat. Feel free to write any other questions in the chat, or if you want to raise your hand. But I think the chat is good. So here I see one that says, are there any known situations in which the state has invoked mediation? So which the state has invoked it. I don't personally know off the top of my head if there's been any situations thus far where that's happened already, but Wolf maybe, or Barry, if you guys know of any examples that exist.
Yeah, there have been mediated cases. I couldn't tell you whether they were first raised, or whether mediation was first raised by the state or by the investor. I mean, that's difficult to say. It's interesting if we just look at the bilateral investment treaties. So those are the treaties between countries that are then invoked by investors to bring these claims. There are apparently there are 53 bilateral investment treaties that have mediation provisions in them. So out of the 3,000,
3,000.
Yeah, out of 3,000,
so,
right, exactly.
Right.
But they're the more recent ones. So if you look,
only a few of them are, the most recent ones with the EU have permitted this, and that's because fundamentally the new rules, for example, these ICSID rules, came into force in July of 2022. That's why this panel is so good because we're right on top of all the new developments. So
Right.
it's difficult, but it's not that easy to get there. Isabel, you haven't seen too many of these. Do you think people will be more interested in jumping in and doing mediation now that these new treaties are there?
I do, but I think it will take time. I don't think we're gonna see, this year an abundance of mediation cases arise, but I think gradually there will definitely be an increase. It's just another outlet to resolve disputes, and there's a lot of benefits that we talked about. So we'll see.
And how do you think young lawyers could get into this? Either for training as mediators or maybe as counsel, because you need both. How do you think younger lawyers can get involved in this?
I mean, into this field generally, it is one of a newer field overall, mediation or not, even investor state arbitration hasn't been around that long in the grand scheme of things. So there isn't that many firms in the US or even worldwide or independent practitioners who are engaged with this. So it's just a matter of, seeking out those places that do specialize, using your network, your alumni network, whether it's from this CLE today, whether it's from where you went to school, friends, family, just starting conversations. And something that I do as young lawyers, I subscribe to Global Arbitration Review and ICC YAF, things like that, to sort of get these, constant newsletters about what's going on in the world of international dispute resolution, so you can follow and get familiar with the types of disputes that do arise, because it is really niche, and bilateral investment treaties are not something you can necessarily be taught. So it's good to just keep yourself informed and seek out the right people and the right resources. You can definitely, anyone listening who wants to chat more with me, can definitely reach out to me.
How about bar associations? Are those a good place to look to, or?
Yeah, definitely. Any sort of local bar association or national, probably local bar associations would be useful. There's always events tailored to these sort of issues, and also just individuals that you can easily look up via those databases and platforms to find how you can get involved. There's definitely a lot of opportunity out there. You just have to seek it out because it's not at the forefront right now.
Wolf, before we go to more questions, do you have any other, because you speak at all these events and you are the guy, do you have any other suggestions for how younger associates might want to get involved or get some access here?
Yeah, I think it's important to try to follow what is happening with ICSID, with ECT, with the International Mediation Institute, and I would really also turn people in that direction, because they've got a young members section as well. And that's really a global organization, and I know the young member section is very active there too. So I think it's getting involved with as many of these institutions as possible, because you network with people, and that's the key. And the more people you can network with, the more information you're going to have, the more opportunities you're going to have as well. And as Isabel says, this is really a fairly new area, and it's a critical area. And I think there was another question early on in the chat, because of what's happening now, starting with the pandemic to global trade, what's happening because of the conflict in Ukraine, what's happening because of the energy crisis and climate crisis. I mean, a lot of that is really going to be a hindrance on global trade. And we really have to find ways to resolve disputes in that area in perhaps more collaborative ways as well. And so I think this is an area where there will be the need for a lot of attention. And so that means there's a lot of opportunity. I really think there's a lot of opportunity in this area.
Okay, Isabel, any more questions to take through from the chat?
I think we answered this one, but just if you guys have anything else to add, is there a role for organized international bar associations to identify mediation as a useful tool in conflicts involving states and amplify the need to expand the authority of state representatives to engage in mediation? So I guess what can international bar associations do to further promote mediation? I feel like we touched on this a bit, but if you guys know of anything that international bar associations are doing or how they're involved with this.
Let's turn to Wolf first. I know a pile, but let's go to Wolf first.
No, I mean, yeah, I mean, the IBA itself, the International Bar Association, certainly deals with dispute resolution and mediation as well. So, I mean, it is very much, I think, a focal point for the global legal community, and so I think that's an important place for this discussion to take place. They were actually the very first ones, I would say, 11 years ago, that actually came out with a set of rules. Mediation rules, long before ICSID did. And they, in the sense, when everything was still quite nascent, came up with this idea of using mediation. So the IBA has been quite active in this area. Barry?
So the IBA, ICA, which is another major organization, the American Bar Association, ABA, has been very active in this, both in terms of its international law section and in terms of its dispute resolution section. And these have actually been the most active across the board. But I know that there's a lot of folks, Chartered Institute of Arbitrators in London and in New York, have been very focused on this. So there's a lot more that's out there. So we've got it. Now, we have a limited time and a big questions come in. I'm actually going to jump in on this one, Isabel, if that's okay, because and it came from, there's one at the very beginning and now one at the end. They bookended us. And it's really a question of this, and it's really for Wolf, I think. If you have very high political questions, whether they're going to be questions dealing with war, like what's going to Ukraine and Russia, or whether it's going to be high politics about the use of nuclear power, are these the types of things that could possibly lend themselves to mediation? Or are they exactly the most difficult types of cases to ever mediate? What do you think, Wolf?
Well, I mean, obviously on the diplomatic front, I mean, mediation has been utilized for centuries, really, and a lot of disputes between states have been resolved through mediation. So mediation certainly has a role to play in international disputes. I think what we're talking about here really is more the investment side of it and utilizing it between investors and states rather than state to state. But clearly there's a big role for mediation state to state.
And then the very hot public policy, that may not even be an area for investor state at all. And in fact, increasingly, countries are either deciding like to pull out, like in these ECT pullouts, or are writing treaties that carve out sections in any event, right?
That's right. I mean, well, even the ECT is trying to carve out sections for the EU so that they don't leave the ECT. So, I mean, that's right. I mean, at the end of the day, obviously, states have the power and states can decide whether they're going to give up some of their sovereignty, which they've done through the bilateral investment treaties. Actually, that's what states have done. They've given away part of their sovereignty. Now they're trying to claw it back again, I think, in some situations. So yeah, I mean, that's yet to be seen how that will evolve.
Well, I'm going to leave you all with that magic moment. We have the irrepressible Isabel Manfredonia and the remarkable Wolf von Kumberg, expert extraordinaire on this topic, who have joined us today at the New York Law School ADR Skills program. We want to thank you all for your excellent questions and for your participation. And we look forward to having you come again to our next sessions in this program. I want to thank our panelists. You've been wonderful. I want to thank Professor Peter Phillips and his excellent team at the New York Law School. Thank you all so very, very much.
Thank you.
Thank you, everyone.